21. The importance of remaining in honor and avoiding controversy. Remaining in honor is not a moral preference in commercial law, it is a legal necessity. The speaker reinforces that every interaction with public officials, agencies, and courts must be conducted without engaging in controversy, which in legal terms refers to dispute, denial, or combative behavior. Under the rules of commerce, he who enters into controversy is presumed to be in dishonor, and therefore, the debtor. To stay in honor, one must respond to all presentments, whether lawful or unlawful, with peace, clarity, and due process. This involves asking questions rather than making accusations, tendering conditional acceptances rather than refusals, and maintaining a neutral yet firm record. Even when confronted with procedural injustice or bureaucratic resistance, the correct posture is, I am willing to perform. Please provide proof of claim and authority. This removes any presumption of belligerence or evasion. The law of merchants, which underpins the UCC and international commerce, rewards those who do not enter into dishonor by argument. Courts observe not just the content of one's statements, but the manner in which one proceeds. Documentation, calm language, and respect for the process create the presumption of honor. From that position, all remedies become accessible. Remaining in honor is not weakness, it is commercial power. It preserves standing, credibility, and access to lawful discharge of obligations. Footnote. This section emphasizes that remaining in honor and avoiding controversy preserves creditor status and enables lawful remedy through procedural integrity. 22. The role of notaries, witnesses, and the third-party record. In the enforcement of commercial remedy, third-party validation is a critical evidentiary tool. Notaries, public, private witnesses, and certified mail services serve not merely as procedural formalities but as legal anchors that transform private acts into enforceable public records. The speaker underscores that without third-party corroboration, a presentment or affidavit may be dismissed as a mere claim. With it, it becomes prima facie evidence. A notary public performs an essential function. They do not verify the truth of a document's content but attest to the identity of the signer and the voluntary nature of the act. This verification, often affixed with a stamp and seal, elevates the document into a recognized legal instrument. In commercial law, a notarized affidavit stands as truth unless rebutted by another sworn affidavit of equal or higher authority. Additionally, the use of registered or certified mail with return receipt provides a time-stamped, third-party chain of custody that cannot be lawfully ignored. Together with the notary's seal or witness statement, these elements provide the framework for lawful default, commercial lien, or administrative enforcement. Witnesses serve a similar function when the process occurs outside the presence of a notary. They confirm delivery, signature, and substance. In either case, independent verification transforms private commercial action into public legal consequence. Footnote. This section explains how notaries, witnesses, and mailing services convert private commercial acts into public, enforceable records by providing third-party validation. 23. Enforcing private commercial judgments through administrative process. Once a claim has been perfected through presentment, dishonor, and default, the next step is administrative enforcement. The speaker describes this as a process entirely outside the confines of traditional litigation. A private party, having lawfully obtained a default judgment through unrebutted affidavits and lawful notice, may now proceed to lien the defaulting party or assign the claim to a third-party debt collector or enforcement agency. This phase begins with the creation of an affidavit of obligation or commercial lien, which is then filed into the public record, often with a county recorder, Secretary of State, or a UCC filing office. The affidavit must state, in specific commercial terms, the original agreement, the presentment, the failure to respond, and the resulting dishonor. It must also reference the unrebutted affidavits that serve as the foundation of the judgment. Once recorded, this private judgment may be used to seize assets, garnish income, or offset debts, provided the procedural steps were properly executed and documented. Importantly, enforcement should always follow notice, cure periods, and repeated opportunities for response, in accordance with commercial due process. The process mimics court procedure but operates autonomously through the law merchant, and is recognized under both UCC principles and international commercial law when supported by valid record-keeping. Footnote. This section outlines how private commercial judgments are enforced through liens, offsets, or assignments using administrative filings and public records. 24. The power of affidavits, truth in commerce and default authority. In commercial law, the affidavit is the highest form of testimony and the foundational vehicle for asserting truth. Unlike statements or declarations, an affidavit is a sworn statement of fact, executed under penalty of perjury, and admissible in both public and private proceedings. The speaker explains that when an affidavit goes unrebutted, it establishes a legal presumption of truth, which can be enforced as a commercial judgment. This process begins with the issuance of a sworn affidavit outlining the facts of the case, the notice provided, and the presentment of instruments. When sent with proof of delivery, and no counter-affidavit is received within the specified response window, usually 10 to 30 days, the facts stand uncontested. Under commercial and procedural rules, unrebutted affidavits equal default, and default equals judgment. Affidavits also function as evidence of performance. When documenting a tender of payment, a conditional acceptance, or a protest for dishonor, the affidavit becomes the primary evidence that these lawful acts occurred. This is especially true when accompanied by a notary seal, mailing receipts, or witness attestations. Furthermore, affidavits can serve as the basis for a notice of fault, a notice of default, or the filing of a lien. In all cases, the unrebutted sworn statement becomes enforceable as fact, not because it was proven in court, but because it was never lawfully denied. Footnote. This section establishes affidavits as the ultimate form of uncontested testimony in commerce, forming the legal basis for default, judgment, and enforcement. 25. The administrative record as legal judgment in commerce. One of the most transformative insights offered by the speaker is that a properly constructed administrative record can operate as a lawful judgment, equivalent in force and effect to a court order, when executed in accordance with commercial law. This record is not speculative or symbolic. It is a step-by-step evidentiary chain that documents tender, dishonor, default, and final administrative conclusion. The speaker clarifies that the record must include several key elements: 1. The original offer or presentment; 2. A conditional acceptance or counteroffer; 3. A sworn affidavit of the facts; 4. Proof of delivery, e.g., certified mail or notary presentment; and 5. A notice of fault, followed by a notice of default. When this sequence remains unrebutted and is recorded in a public venue, such as a county recorder or UCC office, it becomes enforceable as an administrative judgment. Such a record is valid not because it is declared so by a court, but because due process was afforded, and the opposing party failed to object. This aligns with the maxims of law: he who does not deny, admits. In commerce, silence following lawful notice is consent, and a properly executed record operates as a form of private law between the parties. This makes the individual, not the court, the originator and enforcer of lawful remedy, with the record itself serving as both the procedure and the judgment. Footnote. This section explains how a properly assembled administrative record functions as an enforceable commercial judgment when left unrebutted. 26. Legal tender, lawful money, and discharging debt without currency. A recurring theme in the speaker's discourse is the distinction between legal tender and lawful money, and how debt can be discharged through performance rather than currency. Under the Uniform Commercial Code and post-1933 legal regime, gold and silver coin are no longer the operative forms of settlement in commerce. Instead, commercial law recognizes the discharge of debt through negotiable instruments, agreements, and lawful tender of value backed by intent and process, not necessarily substance. Legal tender refers to instruments that the government accepts for payment of debts, typically Federal Reserve notes. In contrast, lawful money traditionally referred to coin backed by precious metals. However, In modern commercial practice, both terms have given way to the more general principle of discharge by instrument, that is, payment through commercial paper, bonds, judgments, and other non-cash means. The speaker emphasizes that a properly endorsed draft, conditional acceptance, or judgment, if not dishonored, satisfies the obligation by operation of law. Courts and agencies often seek Federal Reserve notes, but the law does not require settlement in currency, only that a lawful and unconditional tender be made and not dishonored. By understanding the distinction between payment and discharge, and the mechanisms for lawful tender, individuals can navigate commercial obligations with powerful alternatives to fiat transactions, restoring control through procedural remedy rather than financial dependency. Footnote: This section clarifies that debt can be lawfully discharged without currency by tendering valid instruments or judgments under commercial law. 27. Endorsement as the legal act that transfers rights and triggers liability. At the heart of commercial instruments lies the legal function of endorsement, which is the act of signing or assigning an instrument in order to transfer title, rights, or liability. The speaker emphasizes that endorsement is not merely a formality, it is a commercial act of law that binds the endorser and confers standing to the bearer. Under UCC Article 3, an instrument is not complete, or legally actionable, until it is properly endorsed. Endorsements can be blank, special, restrictive, or qualified. However, in the context of administrative remedy and court proceedings, the endorsement typically serves to assign an instrument, such as a judgment or conditional acceptance, to the appropriate party for presentment and discharge. When an individual endorses an instrument without recourse, they are limiting liability. But when endorsement is full and unconditional, it becomes a lawful tender of payment or settlement. The speaker clarifies that by endorsing a judgment and presenting it into the record, the presenter satisfies the obligation to perform. If the recipient, such as a court or agency, fails to respond or dishonors the instrument, they become the liable party. This triggers the sequence of default, fault, and enforcement as outlined in prior sections. In commerce, endorsement transforms the paper into a living instrument, activating its legal effect. Without endorsement, there is no transfer, no obligation, and no remedy. With endorsement, commercial law comes alive. Footnote: This section details how endorsement activates the legal power of a commercial instrument, transferring rights and establishing the basis for lawful remedy. 28. Jurisdictional control through commercial action and language. One of the most crucial yet subtle tools in the realm of lawful remedy is the control of jurisdiction through one's words and actions. The speaker explains that in commercial law, as in equity, jurisdiction is often not taken, it is granted by consent. Whether in administrative proceedings or courtrooms, the language one uses and the process one engages in either grants or withholds jurisdiction to the presiding authority. When an individual responds to a court order, citation, or agency demand without question, objection, or conditional acceptance, they are presumed to be operating under the jurisdiction of the presenter. In contrast, when one responds in writing with a notice of conditional acceptance, a request for validation, or a private administrative remedy, jurisdiction is either rebutted or conditionally granted on terms set by the respondent. This principle is particularly relevant when dealing with courts. By stating, "I am here by special appearance to challenge jurisdiction," or "I conditionally accept your offer upon proof of claim," one avoids entering into general appearance or controversy, and preserves their standing as creditor. Failing to assert this early results in silent consent and a forfeiture of rights. Jurisdiction, then, is not just a matter of venue or law, it is a matter of commercial consent, determined by the procedural acts and precise words of the parties. Mastery of this doctrine is essential to achieving lawful and enforceable remedy. Footnote: This section explains how jurisdiction is conditionally accepted or rebutted through commercial language and process, preserving standing and limiting liability. 29. Commercial liability of public officials for dishonor and default. An often misunderstood but highly potent remedy within commercial law is the ability to hold public officials commercially liable for acts of dishonor, default, or breach of trust. The speaker emphasizes that individuals acting in a public capacity, judges, clerks, agency officers, and law enforcement, are personally accountable when they violate commercial due process or dishonor lawful presentments. While these officials may appear to act with immunity under statutory law, that immunity does not extend to private commercial contracts, especially when the official steps outside the bounds of their delegated authority. When properly noticed and given the opportunity to respond, failure to do so constitutes commercial dishonor, and continued silence may result in default. From there, one may file a notice of liability or initiate an affidavit of commercial lien. Importantly, any commercial claim against a public official must be supported by a complete administrative record. This includes a timeline of presentment, a conditional offer to cure, and a declaration of fault or default when the official fails to rebut or respond. Only then can personal liability attach, and the individual may be pursued commercially, including through bond claims or private enforcement. By removing immunity through the procedural lens of commerce, not confrontation, the individual operates from the private side of the law, holding public actors to account based on their own failure to perform under commercial obligation. Footnote. This section describes how public officials may be held personally liable in commerce when they dishonor lawful process or fail to rebut properly noticed claims. 30. Bonds, surety liability, and the path to enforcement. One of the most strategic avenues for enforcing private remedy against public or corporate actors is through the use of bonds and surety liability. Every public official, officer of the court, and many corporate actors are bonded, meaning they have a financial surety policy guaranteeing their lawful performance. When an official dishonors a valid commercial process, one does not merely seek punitive relief through litigation, instead, one may file a claim against their bond. The speaker emphasizes that a properly executed administrative record, complete with affidavits, notices of default, and presentment receipts, can serve as evidence in a bond claim. If a clerk, judge, or police officer has violated their oath, refused lawful presentment, or failed to respond to conditional acceptance, they have committed a breach of duty. This triggers the surety's obligation to indemnify the injured party. To begin this process, one must locate the bond, often available through public records, human resources departments, or a written request. Once identified, a commercial claim may be sent to the bond underwriter or risk management division, attaching all supporting documentation. A copy may also be sent to the official's supervisor, creating personal pressure for resolution. Unlike lawsuits, bond claims are internal administrative proceedings. When supported by an uncontested record, they are powerful, fast, and lawful. The commercial path of enforcement is not obstructionist, it is precision-targeted remedy using the same infrastructure the system uses to protect itself. Footnote. This section outlines how to pursue remedy through bond claims by establishing commercial liability for public officials who violate lawful duties.